University of Santo Tomas Criminal Law Review, Pre-Week Notes 2016, Part 3. For our topic for today, this is about extinguishment of criminal liability. The criminal liability is totally extinguished in 7 terms. Number 1, by the death of the convict. As to the personal penalties and as to pecuniary penalties, liability therefore is extinguished only when the death of the offender occurs before final judgment. Number 2, by service of sentence. Number 3, by amnesty, which completely extinguishes the penalty and all its effects. Number 4, by absolute pardon. Number 5, by prescription of the crime. Number 6, by prescription of the penalty. Number 7, by the marriage of the offended woman as provided in Article 344 of the RPC. Here's an illustration. Bayot was found guilty beyond reasonable doubt of the crime of rape committed against AAA. Thus, sentencing him to suffer the penalty of reclusion perpetua. CA affirmed the ruling but increased the award of indemnity and offered Bayot to pay AAA moral damages in the amount of 50,000. During pendency of his appeal, Bayot died at the Preston Hospital, as evidenced by the letter of the penal superintendent to the CA. Did the death of Bayot extinguish both in criminal and civil liability? The answer? Yes. Bayot's death during the pendency of his appeal before the Court of Appeals extinguished not only his criminal liability for the crime of rape committed against AAA, but also his civil liability solely arising from or based on said crime. Article 89, paragraph 1 of the Revised Penal Code specifically provides the effect of death of the accused on his criminal as well as civil liability. According to the pertinent provision, criminal liability is totally extinguished by death of the convict as to the personal penalties and as to pecuniary penalties. Liability is extinguished only when the death of the offender occurs before final judgment. It is already unnecessary to rule on Bayot's appeal. Said appeal was still pending and no final judgment had been rendered against him at the time of his death. That case is based on People v. Bayot, GR number 200030, April 18, 2012. Here's another illustration. AAA is the second of 5 children of Amistoso and BBB. AAA was 12 years old when the rape incident happened. Amistoso had sexual intercourse against the will of AAA. Amistoso was charged with statutory rape. However, the RTC and CA convicted him for qualified rape. Insisting upon his innocence, Amistoso appealed to the Supreme Court. In a decision dated January 9, 2013, the Supreme Court affirmed with modification the judgment of conviction against Amistoso. However, the court was belatedly informed that Amistoso had died on December 11, 2012 at the New Bilibid prison due to cardiorespiratory arrest. Yet, the public attorney's office, which represented Amistoso and which was apparently also unaware of its client Timis, still filed a motion for reconsideration of the court's decision on February 22, 2013. What is the effect of the death of Amistoso on his criminal and civil liability pending resolution from court? The answer? Article 89, paragraph 1 of the Revised Penal Code states that criminal liability is totally extinguished by the death of the convict. As to the personal penalties and as to pecuniary penalties, liability therefore is extinguished only when the death of the offender occurs before final judgment. Therefore, the death of Amistoso pending appeal of his conviction extinguishes his criminal liability as well as his civil liability ex delicto. Since the criminal action is extinguished inasmuch as there is no longer a defendant to stand as the accused, the civil action instituted therein for recovery for civil liability ex delicto is ipso facto extinguished, grounded as it is on the criminal case. Undeniably, Amistoso's death on December 11, 2012 preceded the promulgation by the Supreme Court of its decision on January 9, 2013. When Amistoso died, his appeal before the Supreme Court was pending and unresolved. The Supreme Court ruled upon Amistoso's appeal only because it was not immediately informed of his death. Amistoso's death on December 11, 2012 renders the Supreme Court's decision dated January 9, 2013, even though affirming Amistoso's conviction, irrelevant and ineffectual. Moreover, said decision has not yet become final and the Supreme Court still has jurisdiction to set it aside. This case is found in People v. Amistoso, GR number 201447, August 28, 2013. Here's another illustration. Consorte was convicted for murder for the death of Elizabeth Palmar. The Court of Appeals affirmed his conviction. Hence, he elevated his case to the Supreme Court, assailing the incredibility of his conviction. The Supreme Court affirmed, with modification, the conviction of Consorte on July 9, 2014. A motion for consideration was pending resolution before the Supreme Court when Consorte died in New Bilibid prison. His death was evidenced by the death certificate issued by the NBP medical officer and attached in a letter by the officer in charge of the New Bilibid prison informing the court of the update. Did the death of Consorte extinguish his criminal and civil liability pending resolution? The answer: yes, Consorte died before final judgment, as in fact his motion for reconsideration is still pending resolution by the court. As such, his criminal liability as well as his civil liability ex delicto are extinguished by his death prior to final judgment. The death of the accused pending appeal of his conviction extinguishes his criminal liability as well as the civil liability based solely thereon. The death of the accused prior to final judgment terminates his criminal liability and only the civil liability directly arising from and based solely on the offense committed. This case is found in People v. Consorte, GR number 194068, November 26, 2014. Here's another title: Prescription of Crimes. Okay, here's a question from 2000, from year 2000 bar. One fateful night in January 1990, while 5-year-old Albert was urinating at the back of their house, he heard a strange noise coming from the kitchen of their neighbor and playmate Ara. While he peeped inside, he saw Mina, Ara's stepmother, very angry and strangling the 5-year-old Ara to death. Albert saw Mina carry the dead body of Ara, place it inside the trunk of the car and drive away. The dead body of Ara was never found. Mina spread the news in the neighborhood that Ara went to live with her grandparents in Ormoc City. For fear of his life, Albert did not tell anyone, even his parents and relatives, about what he witnessed. 20.5 years after the incident, and right after his graduation in criminology, Albert reported the crime to NBI authorities. The crime of homicide prescribes in 20 years. Can the state still prosecute Mina for the death of Ara despite the lapse of 20.5 years? The answer: yes, the state can still prosecute Mina for the death of Ara despite the lapse of 20.5 years. Under Article 91 of the Revised Penal Code, the period of prescription commences to run from the day on which the crime is discovered by the offended party. The authorities or their agents, in the case at bar, the commission of the crime was known only to Albert, who was not the offended party nor an authority or an agent of an authority. It was discovered by the NBI authorities only when Albert revealed to them the commission of the crime. Hence, the period of prescription of 20 years for homicide commenced to run only from the time Albert revealed the same to the NBI authorities. Another illustration here. A killed his wife and buried her in the backyard. He immediately went into hiding in the mountains. 3 years later, the bones of A's wife were discovered by X, the gardener. Since X had a standing warrant of arrest, he hid the bones in an old clay jar and kept quiet about it. After 2 years, Z, the caretaker, found the bones and reported the matter to the police. After 15 years of hiding, A left the country but returned 3 years later to take care of his ailing sibling. 6 years thereafter, he was charged with parricide, but he raised the defense of prescription. Under the Revised Penal Code, when does the period of prescription of the crime commence to run? And when it is interrupted? And is A's defense tenable? Explain. This was asked during the 2010 bar exam. For the first question, under the Revised Penal Code, when does the period of prescription of a crime commence to run? Okay, under Article 91 of the Revised Penal Code, the period of prescription commenced to run upon discovery of the crime by the offended party, the authorities, or their agent. The question: when is it interrupted? The answer: it is interrupted upon filing of the complaint or information in court. Another question: is A's defense tenable? The answer is no. Parricide prescribes in 20 years. The period of prescription started only when Z reported the matter to the police, which is equivalent to 10 years of hiding from the time of the reporting to Z. The period of 3 years shall not be counted since he is absent from the Philippines. The filing of the charge 6 years thereafter is well within the prescriptive period. Another question here. Goyena filed with the city prosecutor a complaint for slight physical injuries against Bautista. After conducting the preliminary investigation, the prosecutor issued a recommendation for the filing of information against Bautista. Such recommendation was approved by the city prosecutor, but the date of such approval cannot be found in the records. The information was, however, filed with the METC of Manila only on June 20, 2000. Bautista sought the dismissal of the case against him on the ground of the 60-day period of prescription from the date of the commission of the crime. Has the crime prescribed? The answer: no, the crime has not prescribed. It is a settled rule that the filing of the complaint with the fiscal's office suspends the running of the prescriptive period. The office of the prosecutor miserably incurred some delay in the filing of the information, but such mistake or negligence should not unduly prejudice the interest of the state and the offended party. As held in People versus Olarte, it is unjust to deprive the injured party of the right to obtain vindication on account of delays that are not under his control. All that the victim of the offense may do on his part to initiate the prosecution is to file the requisite complaint. This case is found in People versus Bautista, GR number 168641, April 27, 2007. Here's another question. A. While serving sentence for homicide, escaped but was rearrested and was sentenced for evasion of service of sentence. Later on, he was granted absolute pardon for homicide. He now claims that the pardon includes the evasion of sentence, since the latter crime incurred or occurred because of homicide. Is A's contention correct? The answer: no. Pardon by the chief executive must specify the crime and does not include those not specified in the pardon. And that's the end of the Book 1 of Criminal Law. And now for the next title, or for the Book 2, Crimes Against National Security. As a rule, crimes against national security can only be committed in times of war. What are the exceptions under this rule? Okay, the following crimes can also be committed even in times of peace. Number 1, espionage. Number 2, inciting to war or giving motives for reprisals. Number 3, violation of neutrality. Number 4, mutiny and piracy. Here's a question here. How may treason be proved and explained? The two ways of proving treason are: number 1, by the testimony of at least 2 witnesses to the same overt act, which is the 2-witness rule. Number 2, the confession of guilt made in open court. The first mode of proving treason is by testimony of at least 2 witnesses to the same overt act. There must be 2 witnesses that must corroborate each other as to the overt act performed by the offender. Therefore, treason cannot be proven by mere circumstantial evidence. The second mode of proving treason is by the confession of guilt made in open court. The confession of guilt must be judicial confession of guilt made by the accused in open court. Extrajudicial confession of guilt will not suffice to bring a conviction in the crime of treason. Here's another question. In a time wherein the Philippines is involved in a war with another country, the offender XXX Filipino citizens commanded women for the enemy troops. Are they liable for treason? The answer is no. The act of commanding women to the enemies does not constitute a treasonable act. This act of commanding women to the enemies to satisfy the lust for the enemies is not a treasonable act, because whatever benefits it would give to the enemy would have been trivial and perceptible in nature. It is only secondary and not the primary purpose of the said offender. This illustration or this case is found in People versus Paris, GR number L DOS 856, April 18, 1949. Okay, piracy vis-a-vis mutiny. In piracy, offenders are strangers to the vessel. Hence, offenders are neither passenger nor crew or members. In mutiny, offenders are members of the complement or the passengers of the vessels. In piracy, this is done with animo furandi or intent to steal and with the intention of universal hostility. While in mutiny, this is against the authority of the commander of the ship. While in piracy, intent to gain is an element of piracy. While in mutiny, intent to gain is immaterial. In piracy, this is attack from the outside, while in mutiny, this is attack from the inside. So that's the difference between the piracy and the mutiny. Here's another illustration. A, B, and C hijack a plane bound to Malaysia. In the course of the hijack, D, a passenger, was shot and killed. The court charged and convicted them for the violation of hijacking law and murder. Is the court correct? The answer? No. The charge should only be RA number 6235 or violation of anti-hijacking law. A, B, and C should not be charged with a separate crime of murder because of the act of killing a passenger or complement in violation of RA number 6235 will only bring a higher penalty. Murder should not be charged separately. Here's another title, Crimes Against the Fundamental Laws of the State. Okay, what are the 3 ways of committing arbitrary detention? This was asked in 2006 bar exam. Okay, there are 3 ways of committing arbitrary detention. Number 1, by detaining or locking up a person without any legal cause or ground thereof, purposely to restrain his liability. Number 2, by delaying delivery to the proper judicial authority of a person lawfully arrested without a warrant. Number 3, by delaying release of a prisoner whose release has been ordered by the competent authority. Here's a question. Is there an arbitrary detention even if the offended party were not kept in an enclose? The answer, yes. There is arbitrary detention even if the victims were not kept in an enclose. The prevailing jurisprudence on kidnapping and illegal detention is that the curtailment of the victim's liberty need not to involve any physical restraint upon the victim's person if the act and actuations of the accused can produce such fear in the mind of the victim sufficient to paralyze the latter to the extent that the victim is compelled to limit his own actions and movements in accordance with the wishes of the accused, then the victim is, for all intent and purposes, detained against his will. This is found in Astorga versus People, GR number 154130, October 1, 2003. Okay, true or false, a policeman who, without a judicial order, enters a private house over the owner's opposition is guilty of trespass to dwelling. This was asked in Bar 2009. The answer is false. The crime committed by the policeman in this case is violation of domicile, because the official duties of a policeman carry with it an authority to make searches and seizure upon judicial order. He is therefore acting under the color of his official authority. Okay, here's another illustration. Policeman Conde, Avenido, Digran, Rufano, and Balulot, thinking that Galvantes was armed with a gun, pointed their firearms at him and asked for his gun. Conde went near Galvantes' jeep and conducted search without a search warrant. After a while, they saw the super .38 pistol under the floor mat of the jeep. Galvante then filed complaints before the ombudsman. One of the criminal complaint he filed was warrantless search. And would the complaint proper? The answer: no, the complaint for warrantless search charges no criminal offense. The conduct of a warrantless search is not a criminal act, for it is not penalized under the RPC or any other special law. What the RPC punishes are only two forms of searches, which are search warrants maliciously obtained and abuse in service of those legally obtained under Article 129 and searching domicile without witnesses under Article 130. So Galvante did not allege any of the elements of the foregoing felonies in his affidavit complaint. Rather, he accused Conde, Avenido, Digran, Rofano, Balulot of conducting a search on his vehicle without being armed with a valid warrant. This situation, while lamentable, is not covered by Article 129 and 130 of the RPC. The remedy of petitioner against the warrantless search conducted on his vehicle is civil in nature under Article 32 in relation of the Article 2219, paragraph 6 and 10 of the Civil Code. This case is in Galvante versus Casimero, JR number 162808, April 22, 2008. While in a pabasa was going on at a municipality in the province of Tarlac, Reyes and his company arrived at the place, carrying bolos and crowbars, and started to construct a barbed wire fence in front of the chapel. The chairman of the committee in charge of the pabasa persuaded them to refrain from said acts. A verbal altercation then ensued. The people in attending the pabasa left the place hurriedly in confusion, and the pabasa was discontinued until after investigation. Reyes and his company, in their defense, claimed that the land where the chapel is built belongs to the Clemente family, of which they are partisans. Are the accused guilty of the crime under Article 133? The answer: no. Article 133 of the RPC punishes acts notoriously offensive to the feelings of the faithful. The construction of a fence, even though irritating and vexatious to those present, it is not an act as can be designated as notoriously offensive to the faithful. In this case, the accused were acquitted of the violation of the Article 133 of the RPC, but they were found guilty of the violation of the Article 287 of the RPC, for the circumstances showed that their acts were done in such a way as to vex and annoy the parties who had gathered to celebrate the pabasa. This case is found in People versus Reyes et al., JR number L-40577, August 23, 1934. Wow, that was very long time ago. Okay, here's another title. Crimes Against Public Order. What is the theory of absorption in rebellion? Whenever in the course of committing rebellion, murder, homicide, arson, physical injuries, and other common crimes are committed, and these common crimes are furtherance to, incident to, in connection with the rebellion, is considered as absorbed in the crime of rebellion. Only one charge of rebellion should be charged against the offender. Okay, here's the difference between the coup d'etat and rebellion. In coup d'etat, essence is a swift attack against the government, its military camp or installations, communication network, and public facilities and utilities essential to the continued exercise of governmental powers. While in rebellion, the essence of the crime is public uprising and taking up arms against the government. In coup d'etat, the purpose is merely to paralyze the existing government. In rebellion, the purpose is to overthrow the existing government. In coup d'etat, can be committed not only by means of force and violence, but also by means of intimidation, threat, strategy, and stealth. In rebellion, can only be committed by the means of force and violence. In coup d'etat, may be carried out singly or simultaneously. In rebellion, it requires a public uprising or multitude of people. In coup d'etat, principal offenders must be members of the military, national police, or public officers with or without civilian support. In rebellion, offenders need not be uninformed personnel or the military or the police. So that's the difference between the coup d'etat and rebellion. Here's another question here. As a result of the killing of SPO3 Jesus Locelo, Elias Lovidioro was charged with the subsequently found guilty of the crime of murder. On appeal, Lovidioro claims that he should have been charged with the crime of rebellion, not murder as being a member of the NPA. He killed Locelo as a means to or in furtherance of subversive ends. The Solicitor General opposing appellant's claim avers that it is only when the defense had conclusively proven that the motive or intent for the killing of the policeman was for political and subversive ends. Will the judgment of the rebellion be proper? And between the appellant and the Solicitor General, who is correct? The Solicitor General is correct. It is not enough that the overt acts of rebellion are duly proven. Both purpose and overt acts are essential components of the crime. With either of these elements wanting, the crime of rebellion legally does not exist. If no political motive is established and proved, the accused should be convicted of common crimes and not of rebellion. In cases of rebellion, motive relates to the act and mere membership in an organization dedicated to the furtherance of rebellion would not by and of itself suffice. So this is found in People versus Lovidioro GR number 112235, November 29, 1995. Question here. What are the elements of the second form of direct assault? Okay, number one, the offender is that the offender makes an attack, employs force, makes a serious intimidation, makes a serious resistance. and that the person assaulted is a person in authority or his agent, that at the time of the assault, the person in authority or his agent is engaged in performance of official duties, or that he is assaulted or on occasion of such performance, and that the offender knows that the one he is assaulting is a person in authority or his agent in the exercise of his duties, and there is no public uprising. Is the crime of direct assault based on material consequence of the unlawful act? The answer, no. The essence of the crime of direct assault is the spirit of lawlessness and the contempt of hatred for the authority or the rule of law. Okay, appellant with about 20 armed men and Hook Commander Torrio raided and attacked the house of Punzalan, his political adversary and incumbent mayor of Tiaong, Quezon, with automatic weapons, hand grenades, and bottles filled with gasoline. The raid resulted not only in destruction of Punzalan's house and that of others, but also in the death and injuries to a number of civilians. The CFI found appellant guilty of complex crime of rebellion with multiple murder among others. Was the lower court correct? The answer, no. The accused is guilty of sedition, multiple murder, and physical injuries among others. The purpose of the raid in the act of the raiders in rising publicly and taking up arms was not exactly against the government, and for the purpose of doing the things defined in Article 134 of the Revised Penal Code under the rebellion. The raiders did not even attack the Presidencia, the seat of the local government. Rather, the object was to attain by means of force, intimidation, and etc. One subject to wit, to inflict an act of hate or revenge upon a person or property of public official. Lee Ponsalan was then mayor of Tiaong. Under Article 139 of the same code, this was sufficient to constitute sedition. This is People versus O'Malley et al. GR number L-5808, November 29, 1954. Another illustration, as the town president failed to pay his salaries, the accused, accompanied by 4 armed men, went to the house of the former and compelled him to force to leave and go to the Presidencia. The accused kept the town president there and confined until the relatives of the latter had raised enough money to pay what was due the accused and the armed men as salaries. What crime did the accused commit? The facts constitutes the crime of direct assault. There is no public uprising when the accused, accompanied by armed men, compelled by force the town president to go with them to proceed to the municipal building and detain him there. By reason of detaining the town president, the accused inflicted upon a public officer an act of hate or revenge. This is one of the objects of sedition, which is essentially what the accused intended to attain. This is U.S. versus Dirain, JR number 1948, May 5, 1905. A lady professor was giving an examination. She noticed B, one of the students, cheating. She called the student's attention and confiscated his examination booklet, causing embarrassment to him. The following day, while the class was going on, the student B approached A and without any warning slapped her. B would have inflicted further injuries on A had not C, another student, come to A's rescue and prevented B from continuing attack. B turned his ire on C and punch the latter. What crime or crimes, if any, did B commit and why? This was asked in 2002 bar. The answer, B committed 2 counts of direct assault. One for slapping the professor. Because A was then conducting classes and that in the exercise of her authority. And another one for the violation of the student C, who came to aid of the said professor. By express provision of the Article 152, teachers and professors of public and duly authorized private schools, colleges, and universities in the actual performance of their professional duties or on the occasion of such performance are deemed person in authority for purpose of the crime of direct assault and of resistance and disobedience. And any person who comes to the aid of person in authority shall be deemed an agent of person in authority. Accordingly, the attack of C is, in the eyes of law, an attack of an agent of person in authority, not just the attack on the student. Another question here. During election time, Isko was found in possession of an unlicensed firearm. Arrested, he was charged with 1. Violation of the Comelec gun ban, 2. Illegal possession of unlicensed firearm. During the arraignment, for the violation of Comelec gun ban, he pleaded not guilty. However, during the arraignment for illegal possession of an unlicensed firearm, he filed a motion to quash the information, arguing that he cannot be charged of the illegal possession of unlicensed firearm because the law says that you can only be charged of the offense provided that no other crime is committed by the person arrested. Is this contention correct? No, his contention is wrong. When the law says, provided that no other crime is committed by the person arrested, the word committed means that there is already a final determination of guilt. A final conviction of guilt based on a successful prosecution or judicial admission. In this case, he was not yet convicted. He was only being prosecuted. Therefore, both cases can proceed. However, the moment he is convicted of violation of the Comelec gun ban, he should be acquitted of illegal possession of unlicensed firearm. This is Celino Senior versus People, GR number 170562, June 29, 2007. Here's a question here. Who are deemed to be persons in authority and agents of persons in authority? The answer, person in authority are those directly vested with jurisdiction, whether as an individual or as a member of some court or government corporation, board, or commission. Barrio captains and barangay chairmen are also deemed person in authority. While the agents of person in authority are persons who, by direct provision of law or by election or by appointment by competent authority, are charged with maintenance of public order, the protection and security of life and property, such as barrio councilman, barrio policeman, barangay leader, and any person who comes to aid of a person in authority. In applying the provisions of Article 148 and 151 of the RPC, teachers, professors, and persons charged with the supervisions of public or duly recognized private schools, colleges, and universities, and lawyers in the actual performance of their profession duties or on the occasion of such performance shall be deemed persons in authority. Okay, here's another case. Saidiko, the cook and waitresses in his restaurant, were on the way home when they were signaled to stop by a police officers who asked Saidiko to open the vehicle's door and alight for a body and vehicle search. When Saidiko opened the vehicle window, he insisted on a plain view search. Obviously irked by by this remark, one of the policemen told him he was drunk, pointing to three empty beer bottles in the trunk of the vehicle. The officers then pulled Saidiko out of the vehicle and brought him to the hospital ng Maynila, where they succeeded in securing a medical certificate under the signatures of one Dr. Harvey Balokating, depicting Saidiko was positive of alcoholic breath, and although no alcohol breath examination was conducted, Saidiko was detained and released only in the afternoon of the following day, when he was allowed to undergo actual medical examination, where the resulting medical certificate indicated that he has sustained physical injuries but negative for alcohol breath. Is Saidiko criminally liable for a crime? The answer, no. It is fairly clear that what triggered the confrontation standoff between the police officers on one hand and Saidiko on the other was the latter's refusal to get off of the vehicle for a body and vehicle search, juxtaposed by his existence on a plain view search only. Saidiko's twin gestures cannot plausibly be considered as resisting a lawful order. He may have sounded boorish or spoken crudely at that time, but none of this would make him a criminal. So it remains to stress that he has not, when flagged down, committed a crime or performed an overt act warranting a reasonable inference of criminal activity. The two key elements of resistance and serious disobedience punished under Article 151 of the RPC are that, number one, the person in authority of his agent is engaged in the performance of official duty or gives a lawful order to the offender. Number two, that the offender resists or seriously disobeys such person or his agent. There can be no quibble that the officer and his apprehending team are persons in authority or agents of the person in authority manning a legal checkpoint. But surely Saidiko's act of exercising one's right against unreasonable searches to be conducted in the middle of the night cannot, in context, be equated with disobedience, let alone resisting a lawful order in contemplation of Article 151. This case is Saidiko versus People, GR number 202692, November 12, 2014. Here's for the last question of this part 3. Manny killed his wife under exceptional circumstances and was sentenced by the RTC Dagupan of Dischero, during which he was not allowed to enter Dagupan City. While serving sentence, Manny went to Dagupan City to visit his mother. Later, he was arrested in Manila. Did Manny commit any crime? This was asked in 1998 bar. Yes, Manny committed the crime of evasion of service of sentence when he went to Dagupan City, which he was prohibited from entering under his sentence of dischero. A sentence imposing the penalty of dischero is evaded when the convict enters any of the place or places he is prohibited from entering under the sentence or come within the prohibited radius. So, although dischero does not involve imprisonment, it is nonetheless a deprivation of property. And that's the end of our part 3 criminal law review. And be back for the part 4. Thank you so much for listening. I do hope I contributed something to help your criminal law review for the Philippine bar exam. I am doing this reading or audio to help also myself as I am struggling with my focus in reviewing the bar exam. I really find it hard to study, especially reading these notes, so I decided to make this video so that even if I am doing something or I am in public places, I still be reviewing the bar in my earphones. If you want also a copy of my reading audios, please send me a message, or if you want me to read some other bar reviewers in my email ad, sender5681 at gmail.com, or to my Facebook page, sender5681. It would be a pleasure to help others while I am reviewing for the bar exam, and I am so happy to share these things to my fellow bar candidates. Thank you so much, and God bless.